Hello, ladies and gentlemen. Emeku Gwonye again. There was a subject we talked about yesterday, which I think we should emphasize or dwell more upon today, and that has to do with the issue of custody of children. In the event that husband and wife or mother and father are separating and no longer going to be together, either they're divorcing or they're pursuing judicial separation, the issue of custody of the minor children of that union will come up. Custody basically means which of the two parents should be with the child. Which of the two parents should stay with the child. Whoever gets the child is called the custodial parent. He gets the child. The other parent is the non-custodial parent. That means that parent will have to get a right of visitation, which means right to see the child. A lot of the time people don't understand what visitation meant. They think it means that the father will be visiting the child. To some extent, yes. Visitation means basically right of access. Right of access, and access could take several forms. It could be by telephonic processes. It could be by direct physical encounter. It could be by such physical togetherness with a child, could be supervised or unsupervised in a private place or in a public place. But the question which we want to talk about today is the issue of custody. Who gets custody? What determines who gets custody? A member of the DPA, confronted me yesterday with a question, and her question was, she wanted to know the age at which the father must get the children. I was surprised because I realized that this is a feeling that is widespread. A lot of people assumed that there is an automatic cutoff point in terms of age at which the father automatically gets custody. And they think that there is, by implication, a particular age bracket within which the mother must have custody. There is no such thing. The law does not create any automatic age cutoff point for any custodial decision. The only thing you've had, and which we believe has been misunderstood, is the general commonsensical notion that the younger a child is, the more dependent the child would be on its mother. Of course, when a baby steps out of the womb, the baby depends on the mother, primarily breastfeeding. So, the younger a child is, the more likely it is that the mother will get custody. But watch my word, the more likely it is. There have been situations where a father could get custody of a 5-month-old child, or even a 3-month-old child. And there had been a situation where a mother had custody of a 17-year-old child. So what determines custody is not any notion of automatic cutoff point. However, the older the baby is, the less dependent the child is on the mother physically, or on the parent. So imagine a 14-year-old child. He doesn't need mom to cook food for him. He doesn't need mom to bath. He doesn't need mom to wash his clothes. So he may have stay with his father, even though his father is a businessman that is hardly at home. Whereas if the baby was 3 years old, he can't stay with a father that is not there. Why? Because a 3-year-old child is very likely dependent on the mother. So, but also remember that these roles could reverse, and it may be the father that stays at home while the mother is the business person. If that is the case, the same reasoning will work. So, now you have to understand, if they ask you, what do you think controls the decision over who gets custody of the child? It is called the best interest of the child analysis. This means that the court is going to ignore all these issues of father, mother, cutoff point, automatic age limit, and the court is going to focus on the child and ask, what is in the best interest of this child? The court will look at a range of factors, so many factors, limitless range of factors. It's not necessary for me to list this, but all I can tell you now is that a good lawyer representing each party will itemize various factors and points which he believes will enable the court grant custody to his own client. And they will discuss these things. Each lawyer is trying to persuade the court that it is in the best interest of this child for the child to stay with this particular parent. One other thing you must avoid, which we have seen in Nigeria often, is the notion that because the mother has no job, she can't have custody. Indeed, the truth is the opposite. We can as well reason that because the mother has no job, she will have more time for the children. Because the mother has no job, she will be more attentive to the needs of these children. Therefore, the fact that the mother has no job could be a factor favorable to the decision for her to get custody. So the notion, the court is not going to take into consideration the economic strength of both parties in determining custody question. Why? Because the law has already created a means of ensuring that the richer parent transfers wealth or funds to the poorer parent for the benefit of the child. So insofar as the law has a room for transfer of income, transfer of wealth from one parent, the richer parent, to the other parent, the poorer parent, in the interest of the child, it becomes immaterial. It becomes irrelevant whether the mother is rich or poor. Also, the same principle of law allows the court to order the richer parent to pay the rent or to provide accommodation for the benefit of the child, even though the child is with the other parent. So this notion that the woman has no job, therefore she's not entitled to custody, it is wrong. However, in an individual case, it may be that the woman actually needs time, free time, so she could look for a job and improve her life. We have seen situations where the mother says, well, I want the man to have custody because I need time to go look for a job, to go back to school, to do a whole lot of things. It is not wrong either. But one thing I want you to understand today, if you're listening, is this. The fact that you don't have money is not a reason for you to lose custody of your children. The fact that you don't have accommodation is not a reason for you to lose custody of your children. If the other parent has money to provide accommodation, feeding and upkeep, the court will order him to transfer wealth. Indeed, the court also has been able to order that the use and possession of a house be kept for the woman for the benefit of the children. So the man may be asked to leave his house. Yes, I call it his house, assuming he had bought that house before he married the woman, and the woman came in there into the house and they're living there. The court can tell the man, very well, we want the house to be left for the use and possession of the mother for the benefit of the children. Use and possession does not mean that the house belongs to the woman now. No, the man still owns the house. But the court wants the children to live in that house for the time being until they attain a particular age, maybe an age of maturity, or until such a time that the man will be able to provide an alternative, conducive accommodation for the children. So, get this point today, because it keeps recurring in our discussion, and I hear people talk about automatic cutoff points, and that is not right. Also, there is nothing like being too poor to have custody or being too unemployed to have custody. I will turn off the event now and I will continue later. Ladies and gentlemen, thank you so much for listening.